When can a property owner be held liable for a person's injuries in Florida? Hi, my name is Charles Buist, and I'm a personal injury and wrongful death attorney in Orlando, Florida. And today, we're going to be talking about premises liability. So let's get right into it. We'll start out by talking about the different types of premises liability accidents. To give you a broad view, premises liability claims are typically brought when someone dies or suffers injuries as a result of an unreasonably dangerous condition on a person's property or on the property of a business. So, the most common types of premises liability claims are slip and fall and trip and fall cases. However, premises liability also includes things like amusement park accidents, swimming pool accidents, negligent security, mold exposure, animal attacks, and any other situation where a person gets hurt because of an unreasonable hazard on the property. Now, let's jump into liability. What is a property owner's duty of care? In other words, what duty does a property owner owe someone who comes onto the property? Well, in most states, this boils down to whether the injured person is considered a trespasser, a licensee, or an invitee. In Florida, the difference between a licensee and an invitee is a bit more blurry than in other states. So for this video, we're just going to stick to the basics. Generally speaking, property owners do not owe a duty to a trespasser. Thus, the real issue is whether the injured person is an invitee, which in Florida is a person that comes onto the property for the benefit of the landowner. So for example, a person that goes into a grocery store to buy groceries and then slips on a puddle of fluid would be an invitee because that person went into the grocery store to spend money on products, which is a benefit to the grocery store. Now, let's talk about what duty a landowner owes an invitee, okay? In Florida, if there's a condition that's dangerous to invitees, a landowner has a duty to fix that hazardous condition or to warn invitees about any hazardous condition that the landowner knows about or should know about through the exercise of reasonable care. So it's pretty simple. If there's a dangerous condition the landowner knows about, the landowner should fix it. And if the landowner can't fix it right away, he at least should warn people about it. So if there's a dangerous condition that the landowner should know about, the landowner needs to fix it or warn about it. For example, if there's a puddle of soapy water in the grocery store aisle and it stays there for an hour before someone walks by and slips in it, then the landowner can't argue they simply didn't know about the condition. Because if someone had simply checked the aisles over the past hour, it would have alerted the landowner to the hazard. And so the landowner reasonably should have known. The same duty a landowner owes to an invitee, he owes to an invited licensee. An invited licensee in Florida is someone who can be called a social guest. This is basically just someone you invite to a party or to some other social event. Well, that's all I have for you today. If you have any questions about premises liability claims, just give us a call. We're happy to give you a free legal consultation and talk with you about your potential case. All you have to do to schedule your free consultation is call us at the number below in the video description. Or you can reach out to us at www.carelesscompany.com. Thank you so much for watching this video, and we'll see you next time.